If a party asserts impossibility as a defense to a contract claim, just how impossible does performance have to be? The court in Bush v. ProTravel International Incorporated considered the possibilities. In May of 2001, Alexandra Bush booked an East African safari honeymoon for herself and her fiancé through ProTravel. Bush paid a deposit of $1,500, representing 20% of the total price. The safari was scheduled to begin on November 14th. Bush signed a registration form providing that if she canceled more than 60 days prior to the trip, she'd pay a penalty of $50 per person for a total of $100. If she canceled between 60 and 30 days before the trip began, she'd pay a penalty of 20%, or her entire deposit. The 60-day trigger occurred on September 14, 2001. Due to the September 11th terrorist attacks and the uncertain state of international travel, Bush and her fiancé immediately decided to cancel their trip. Bush attempted to call ProTravel from her Staten Island home, but in the aftermath of the attacks, phone service throughout New York City had been interrupted. Bush was also unable to travel to ProTravel's Midtown Manhattan offices due to a government-imposed lockdown and travel restrictions. As a result, Bush couldn't communicate the cancellation to ProTravel until September 27th. Bush requested the return of her deposit, but ProTravel refused. Bush sued ProTravel for the return of her deposit, arguing that unforeseen circumstances made it impossible for her to communicate her cancellation more than 60 days before the trip was to begin. ProTravel then moved for summary judgment dismissing her case.